Now we're going to practice questions and more questions for national and Texas state at the end so that you can pass that real estate exam. So you're here to learn and prep in order to take your national real estate exam or Texas state real estate exam. National applies to everybody. So this is recorded. So anybody watching the replay, hey, fast forward in between questions. It's designed to allow students to participate during the session or during the live, and come join us. Come on down. So this is Wild Lillie Handy coming to you from San Antonio, Texas with YouTube AgentPrep. So for participating, I ask that you type the question number and the letter answer, and I will point out any answers that are incorrect and explain them. All right, here we go. So this is the book that we're using by the Metling Father and Son Texas Real Estate License Exam, and it has national for all 50 states. There are 26 books published by this author, and they're adding for 26 states, and they're adding more states every year. So you can purchase the book to study the national questions. In addition, in the description below, I do have some books that you can download for free. Texas Real Estate Sales Exam 4th edition. It's an old book, but excellent national questions and also state. So it's free. You can also buy it on Amazon. And should you click on one of my Amazon links, Amazon pays me an affiliate fee. All right. And within 24 hours, anything you purchase, I get credited. Okay, so let's continue where we're at. And we're still with encumbrances, liens, title transfer and recording, and leases. We did a lot of leases on Saturday. And we're on page, for the questions, we're on page 143, and the answers are on page 248. All right, here we go. Let me make that a little bit larger for you. Ooh, that didn't go large, huh? All right, 261. A homeowner goes bankrupt and the lender forecloses on her residence. In the foreclosure sale, the proceedings are insufficient to pay off the loan, and the court orders other property sold to cover the shortfall. This is called we did this one, but that's okay. Repeat, repeat, repeat. A strict foreclosure. B, suit for specific performance. C, equity foreclosure judgment. Or D, deficiency deficiency judgment. Type your answer in the chat. Anyone? The answer is D. Deficiency judgment. So when there isn't enough money to pay off the loan because the sales price of the home was below the loan balance, then there is a balance that is still due. That is a deficiency judgment, and there'll be a payment plan created with the lender. All right, number 62. Okay, I'm just checking something here. All right, all is good. So to make a successful claim of adverse possession, the adverse possessor must satisfy which of the following criteria? A, the possession must have been concealed without permission and for a statutory period of time. B, the possession must have been concealed for the necessary unconcealed for the necessary length of time and without permission. C, the possession must be with intent, secretive, notorious, and hostile. Or D, the possession must be open without permission for the statutory period of time and within the number of permitted intervals. So every state has a little bit different national laws. However, the answer applies, okay, to any state. So type your answer in the chat. So remember, when anything is done adversely, adverse, that is against the will of someone, against the owner, and they're having possession. They've been using the property, possessing it, enjoying it for a certain number of months. Okay, and the statute of limitation, that applies. The adverse possessor is sometimes referred to as a squatter, somebody that the owner really doesn't want there. However, if the owner did not make sure that they leave and they continue to stay there, though that is a quiet agreement that the owner allowed them to stay there. So adverse possession, okay, and the adverse possessor, okay, that's the individual possessing it. So vocabulary, okay. So the possession must have been concealed. No, so it has to be open and notorious. It has to be visible to anybody and everybody. That's one of the rules. And they have to have been there consecutively, okay, without moving out or coming back. It has to be consecutive. So the answer here, okay, is B. The possession must have been unconcealed, open, for the necessary length of time and without permission. Okay. And the last one, D, does not apply because it says within a number of permitted intervals. Well, it's not permitted, right? It's adversary. It's against the owner's will. And if the owner is from out of state, they may not know and nobody informed them. Therefore, this individual has been able to live there and enjoy the property and possess it. They don't have all the bundle of rights. So what they're going to try to do now is request to take ownership of that parcel, that piece of land, and they can take it to court and win. Following the laws and the conditions, okay, and the requirements. So it has to be unconcealed. So notoriously open to everyone for a necessary length of time. In some areas, it's 10 years and without permission. So they end up using it, maintaining it, and consecutively, continuously. No interruption in the use of the land. All right, number 63. So type your answer in the chat. There's a few of you on here. Not many, but it's understandable for being the day after Christmas. I've worked all day, so I don't have children at home. I have a daughter and 2 boys, and they're chilling out and enjoying their vacation, right, from elementary and junior high. No, high school. All right, number 63. One of the primary benefits of recording conveyances, okay, what is conveyances? Okay, and the recording is to give evidence. What is evidence? To the public. So give evidence to the public that the new owner actually owns the property. So that is public notice. Good evening, Cindy. What is another benefit of recording the homeowner, recording to the homeowner? So the benefit is for the homeowner, the person that purchased the property, that received the conveyance, they received the warranty deed or a quitclaim deed, okay? However it was, or a tax deed, it was conveyed with a deed. So what are the advantages of recording the conveyance, okay? The transfer from an owner to a new person. A, recording instruments establish the title's marketability. B, recording the deed prevents any future clouds on title. C, recording prevents lien holders from illegal credit practices. Or D, recording the deed of conveyance nullifies any and all claims of adverse possession. So which one seems the best? Okay, because a person has to prove that they own it before they were to go and encumber it, get a loan on it, it has to prove that it's been recorded. What else is a benefit? What other one is important as far as A, B, C, or D? Type your answer in the chat. Remember the bundle? Uh-oh, internet. No, it isn't. Cindy, it is not B. Anyone at the future can put a cloud on title. They can go and put a lien on it. The lender puts a lien on it. Someone else, a mechanic's lien, a judgment, property taxes, IRS taxes, child support, spousal support. Those are all liens, judgments that get attached to the property. Recording it doesn't prevent that. It's part of having all the bundle of rights. One of them is to have the right to convey the property, okay, and encumber it. So the answer is A. Recording instruments, the warranty deed, establish that the title is marketable. The title's marketability, meaning the whole public knows that it belongs to that seller and they can sell it. Okay, B says recording the deed prevents any future cloud on title. No, it does not. Clouds can be added by liens recorded on the property. C, let's see, did anybody answer C? No. So C says recording prevents lien holders from illegal credit practices. No. So that would be, oh my gosh, I'm losing my thought here. Homestead, right? Homestead will protect a homeowner from certain creditors. The last one says recording the deed of conveyance nullifies any and all claims of ad possession. No, it does not. Someone can still claim possession. So the only accurate answer here is A. It is an instrument that establishes the title's marketability. If it is not recorded, the title company, when the title company receives the contract from a buyer and the seller through a realtor or an investor, they can submit it. They will check on the marketability. They will check to see if it's recorded. If it's not recorded, then it will get recorded. Okay, so that's the end of the encumbrances, titles, liens, and liens, title transfer and recording, and leases. So we did quite a few sessions, okay, on title transfer and recording. And last Saturday, we did a lot on leases. So if that's a weakness for you, go and watch earlier sessions, this month or last week. All right, so we're now going into test number 3, land use and legal descriptions and contract law. So contract law, okay, applies to all states. That is the generic portion of the contract law. Then there is state-specific contract law. So this is generic to all states. All right, so let me type here the section that we're doing. Oops. So were you in land use? Legal description. Property is identified on all documentation, and contract law. That applies to all states. So if you thought there was only contract law on the state portion of it, no, rethink it. It's also on the national exam. All right, number 1, 3.1. Okay, that didn't work. A little bit more. Okay, 3.1. Which of the following is true regarding the master planning and zoning? Okay, so master planning. So the planning departments for every city, they'll create plans that for 5 years, 10 years, and so forth, so that they can know, what to be able to offer or accept businesses coming into the town, the growth of it, what is required in order to accommodate growth or other businesses coming into the area, into that city. So which of the following is true? There's one correct answer regarding the master plan and zoning. Okay, so the aggregate of zoning ordinances is the master plan. B, a master plan eliminates the need for zoning. C, master planning is a county level function, zoning limited to the city level, and zoning is limited to the city level. And then D, zoning ordinances are a primary means of keeping land use in harmony with the master plan. So the city has a master plan in the planning department, and then every city has its own zoning for the city and for the county. And so you've got vocabulary, aggregate, ordinances, the master plan, what is zoning, and county level functions, city level functions, okay, zoning. And zoning ordinance are a primary means of keeping land in what is in harmony with the master plan. Yes, Miss Cindy, the answer it is D. So zoning ordinances are a primary means of keeping land use in harmony with the master plan. So the city zoning and county zoning, right, allow partitioning the city or not allowing too much dense population in certain areas. And so they enlarge Going County. Oh my goodness, these individuals here. Hold on, let me get rid of a timeout to some X-rated posting. So the answer is 3.1D. It might come in here because of my Wild Lillie Handy. Well, that's not the kind of wild that I am. I'm just a high energy, wild individual, okay? Out of the box thinker. Very analytical. Okay. What number are we on? 32D, 3.1. 3.21. 321. Okay, that's not going to work. All right, there's 3.2. The basic intent of zoning ordinances is to A, establish the basis for public ownership of land for the common good. B, establish rules and regulations. C, specify usage for every parcel within the zoning authority's jurisdiction. Or D, restrict development in unincorporated areas. So every area of the city, they'll allow certain density, right? Higher density means they're allowing more homes in one particular parcel. And when they want to control traffic and other things, they only have one home per parcel, right? So no, it is not A. Take another attempt, Johnny Ware. Hi, Johnny. Thanks for joining us. So I'm going to ask you, Johnny, to go to stream.com/Facebook and give Facebook permission to post your name on here on StreamYard. It's very quick. Go to that link that I just put on Facebook, and it'll take you, 10 seconds or whatever. You just go to that website, give it permission, and then we'll be able to see your name like here, okay, or like Cindy instead of Facebook user. And that way I can also acknowledge you, comment about, not about you, right? Okay, so it is not A. Anyone else? So the answer, for Facebook users, go to this link and give StreamYard permission to post your Facebook name on here. The answer is actually C. Specify usage for every parcel within the zoning authority's jurisdiction. So remember, zoning is one of the police powers, right? So they control, okay, the traffic, the growth, the master plan within the city, in the city and in the county. And so they'll specify, okay, this is R1, which means you can only have one residence, or RM, which you can have multiple residents, like a duplex, triplex. There's R2, R3 for triplex or fourplex. So that's all single residences, right? And that's 1 to 4. Very good, Cindy. So police power, zoning, okay, gives approval on individuals who want to build. They have to go through the city zoning department, city planning department, and approve or reject. And so an application is paid for. They review the plans and give it an okay if it's good, or go back to the drawing board, or that's not allowed. So let's see here. The intent of zoning ordinance is to specify land usage for every parcel within the jurisdiction. In some areas, state law permits zoning ordinances to apply to areas immediately beyond the legal boundaries of the city or county. And sometimes that will be annexed into the city as the city is growing. All right, number 3. Why do zoning authorities create different types of zones? So I just made some comments about that. Why does a city have different types of zones, or even for the county? And for the county, it would be like minimum 1 acre, or minimum 5 acres, or minimum 10 acres, meaning you could only have one dwelling on 1 acre or 5 acres or 10 acres, depending on how it's subdivided. And that's to limit the density, okay, the population that the structure, okay, the substructure may not sustain it. So why do zoning authorities create different types of zones? A, to ensure that a variety of building structures are available in the community. B, to separate land uses so that they do not interfere with each other. C, to prevent high density land uses. Or D, to discourage industrial and commercial users relocating. Hey, Johnny, we can see your name. Awesome. Thank you for that. Wasn't that was quick and easy, huh? Thank you so much. And next time I'll say, hey, would you mind watching on YouTube so that I can get more watch time? It improves the analytics on my channel. So yes, the answer is C. to preserve higher density land uses. So it says one of the primary applications of zoning power is the separation of residential properties from commercial and industrial uses, and also agriculture. Proper design of land use in this manner preserves the aesthetics and value of neighborhoods and promotes the success of commercial enterprises through intelligently located zones. So, a lot of them along the expressway or certain industrial areas or commercial areas, that is not going to infringe on residential's, noise factor, privacy, and so and traffic. So 6 common types of zoning are residential, commercial, industrial, agriculture, public, like public parks, and plant unit development. So although the churches can be built in any zone. So PUDs, plan unit developments. It's called a PUD. So we have, and so PUD versus a MUD, I mentioned that. My internet doesn't go out. I did increase. I had my internet worked on a couple of weeks ago. And even though I have a high speed, sometimes it is still slow. So while MUDs typically focus on water services, so municipal urban developments, municipal unit developments, okay, they have their own water services, sewer, things like that. And they'll also have potentially an HOA. The PID tax would pay for enhanced landscaping, additional open spaces, lakes, and fountains. You'll also find those with golf courses, okay? And the PUD is a public utility district, okay? Public utility district. It's created by the community and operated under an elected board. So the boards are elected, kind of similar to a homeowner association. The homeowner association board members are elected. However, they're not paid. They're volunteers. So, however, it exists solely to provide electricity, water, sewer, and telecommunication within that public utility district. Although PUDs are controlled by the homeowners, they operate independently from the HOA. And so just expanding a little bit. So 3 main types of MUDs. There's a water-based municipal unit district, oil-based MUDs, and synthetic MUDs, okay? So very interesting. You want to go back and learn those acronyms so that you're familiar in case that comes up on the test. I've only dealt in my years, I've only dealt with one MUD, municipal utility district situation. So you have municipal utility district, not unit, or public utility district, public utility district, okay? So just a little education on that, because it doesn't say it anywhere here on the question. However, the answer, should you have the book, does mention, PUDs, PUD or MUD. All right, number 4. The key consideration in granting a zoning exception, okay, a zoning exception known as a special exception is which of the following? A hardship, B, change of zones, C, the public interest, or D, the use was legal prior to the new zone creation. So granting a zoning exception. Okay, why would the city grant a zoning exception? All right, so Johnny mentions he pays mud taxes. So great, you're familiar with that. Where are you located, Johnny? The one I experienced within Mission, Texas, South Texas. Okay, so the key consideration in granting a zoning exception. So in other words, the zoning board or the planning board or the adjustment board, okay, which is actually eventually called the adjustment board, grants certain zoning exceptions, right? And so the individual wanting it, they'll go and apply for the exception. They'll send out, letters to the neighboring properties, have a hearing, let both sides express their concerns or no concerns, and make a decision to approve or disapprove. Okay, the members that are there on the zoning adjustment board. So is it because there's a hardship, or is there a change of zones? So remember, granting a zone exception, not adding or taking away a zone. C, is it for the public interest, or is it for the use of something that was legal prior to the new zone creation? So that's when a zone changes. So it is not D and it's not A. So it's B or C. All right, so Lancaster, Texas, got it. So good, you understand that. So type your answer in the chat, please. The question number and the letter answer. So Cindy so far answered C. So what are most things done to accommodate whom? The consumer, right? And so who is the consumer here? Yes, for public interest, right? For the public interest. So it could be a park, could be a church, it could be, a pond, anything else that is going to be used by the public. So let me see what's next. We're going to do Texas state questions. And you may have lost. Okay, there I am back. All right, number 3. And for now are dealing with land use and zoning. We started out with encumbrances, liens, titles, title and recordings, and leases. Now is for land, legal descriptions, and zoning. Number 5, the intensity of land usage generally refers to what? A, the number of residential building lots per acre. B, the number of people per square mile. C, the number of building permits issued per year within a zoning jurisdiction. Or D, the area of a commercial or industrial facility in relation to the size of the site. The intensity of land usage. You're like, how intense is the land to be used? You build a home. That's pretty intense, right? You build a home, but that's not it. So type your answer in the chat. Right. It is not boy. take another attempt. So B as in boy says the number of people per square mile. So that's part of the demographics. So it says the intensity, not the density. Okay, density would be within a square mile. The intensity of land uses refers to no, the answer is actually D. Okay, the area of industrial facility in relation to the size of the site. Of the land usage. How intense is the land used by commercial industrial facility? Or the whole lot, whole acre is, oh, that's weird. It didn't go through. So let's see what the answer says. So the answer says commercial zoning regulates intensity of usage by limiting the area of store or office per site area. Intensity regulation is further achieved by minimum parking requirements, setbacks, and building height restrictions. So when it comes to commercial and industrial, some of those buildings can be really high, and they need to accommodate for enough parking space for the traffic, right? The customers that come in. So a percentage of the land has to be accommodating parking, and also what is called a reservoir. Now they install a reservoir, which takes a piece of land within that acreage in order to collect water should there be high rainwater like we have in Texas, right? When it rains, it pours like molten salt, Morton salt, right? When you pour it, the Morton salt rains, right? So let me see what else. So it is commercial zoning regulates intensity of usage by limiting the area of store, okay, the size of the store or office per site area. The intensity regulation is further achieved by minimum parking requirement. They have to have a certain number of parking depending on the type of traffic or client that they're going to accept, and then setbacks, right? Residential properties also have setbacks on the back, on the front, and on the sides, and then building height restrictions. So they don't want the height of the building to obstruct the view for anyone else, any of the other businesses. Okay, so you did see the number of building permits issued per year within a zoning. No, that is not the intensity of land usage. And the number of people per square mile, that would be more, part of the demographics, okay? And the individuals that are there, the number of homes in a square mile, that's the density, okay? And the density also is part of the number of people, because how many cars is each family going to have? I live in an area in South Texas. I have a home that the road is very narrow, and a lot of families have a very small parking driveway, and they have 2 cars, 3 cars, 4 cars. So what do? They park it on the side of the road, and it starts to block the entrance and exit of that road. I invested in lots of concrete, right? Concrete stock. No. And so I have huge parking area, because I have lots of brothers that come and visit, and they all bring their vehicles from wherever they're driving. All right. So I'm the only one that has tons and tons of parking. My house is really little. It was just for myself. And so I had lots of space to add lots of parking. I thought, I planned in advance. And some of those owners, okay, do not. So the city and the county have to evaluate that. However, there are less restrictions out in the county than there are in the city. Okay, so we're going to go into Texas state questions, and we're starting out with contracts. Questions on the national, which applies to all 50 states. And when you're prepping for these exam, get a prep book in addition to whatever book you had from the school that you learned. Watch different videos from different individuals, whichever way you learn best. I explain a lot and I point out a lot of keywords, yet there are other instructors, okay, that might be better suited for you. And so I thank you and I'm grateful that you're here and you want to learn a little bit more detail, okay, about those questions. So I years, okay, what things a lot of times to point out to my students. And so, I've been doing this for over 8 years. On YouTube, only a little over 2 years, just 2 years and a week or two, or a week or a month. I did it on Facebook, the private group AgentPrep. That's the page that Johnny is on. And I used to do it in a Keller Williams office when I was there before. Okay, so we're starting out with number 15, which is dealing with contracts. So change your hat and start thinking about contracts. So these here, the contract law on the other have to do with national contract law. So contracts here is specific to Texas. Every state has their own specific state laws and contracts. So this is under what? Promulgated contracts, right? Oh, that's not what I meant. All right, 15.1. Which of the following is true? Okay, so one of the following answers is correct. It's true regarding Texas promulgated contracts. A, they are recommended by the Texas state at the discretion of member attorneys. B, they must be completed with the assistance or approval of a licensed attorney. C, they replace contracts previously prepared by principals attorneys. Or D, they must be used for sale and lease transactions with some exceptions. And Texas state laws, will change every so often. We had laws change about 2 years ago. So we have a new promulgated contract for the 1 to 4 residential family contract. And that was released April 1st of 2021. So we're almost going on 2 years. And that's why we're required in Texas now to take legal update 1 and legal update 2 every 2 years that the license is renewed. All right, so we've got a D from Miss Cindy. Anyone else? Nope. Okay, moving on. All right. Yes, the answer is D. They must be used for sale and lease transactions with some exceptions. If an attorney created the document because the buyer or the seller is using an attorney, well, 6 attorneys help create the contracts in the state of Texas, right? The 13-member committee, and 6 of those are attorneys. So real estate attorneys can write the contracts, they can edit them. Those are the only individuals that can edit them. We use them as they are, and we use any updated promulgated contracts for sale and leases. So the one for sale is sale purchase. And there are for condos, there's for residential 1 to 4, there's for commercial, there's for unimproved land, improved land, new construction, farm and ranch. So lots of different types of contracts that you'll be learning once you start the business. Okay. No, that didn't work. All right. So gonna have to make it smaller, or let's see if I go to the next page, if that'll work. No, that didn't work. All right, number 2. Licensees may not engage in the unauthorized practice of law. Which of the following would constitute such a violation? A, insisting that due to legal nature of property transaction counsel. B, explaining the purpose of a building permit. C, expressing an opinion regarding the validity of a seller's title. Or D, giving a buyer prospect a copy of a subdivision's covenants and restrictions. So we may not engage in one of those 4, A, B, C, or D. So 3 are okay that we can do. 1 is not. If we did it, we would be practicing law. All right, so we've got C. Very good. All right, Miss Cindy and Johnny. Anybody else? Hey, and I greatly appreciate all of you are here. That means you're wanting to study and pass this exam and get 2023. Start with a bang. Hi, Lisa. Thanks for joining us. Yes, the answer is C. Expressing an opinion regarding the validity of a seller's title. Okay, the seller's title, okay, the title search is done by a title company and attorneys review it. So if they have, when a buyer or seller has questions about the title, we refer them to an attorney. They may already have their own attorney, okay? We do not get involved in translating that or giving our opinion. All right, number 3. Moving right along. The practice of completing sales contracts is a tightly regulated activity. Since so much is at stake for consumers, in that context, which of the following is not, okay, not an acceptable practice? So which one can we not do? A, filling in the blanks to a contract form in the middle of negotiations. B, adding a statement of fact desired by both principals. C, adding another blank in a contract clause. Or D, informing a buyer client that an encumbrance on seller's title may be a big problem for the lender. So remember, we fill in the blanks by asking a buyer and a seller questions. So in this business, you must learn to ask lots of questions to learn about their motivation, their interest, their needs, their wants, and keep them focused and help them with their problem or situation. All right, so we have, oh, no answers yet. Sorry, that's my alarm. I used to have a coaching class, which I still do, but I can't attend because you're my priority. So it conflicts with my schedule. All right, Johnny, the answer sounds good. And the answer is C, adding another blank, a contract clause. That is a no-no. We cannot do that, okay? So D, informing a buyer client that an encumbrance on seller's title may be a big problem. Yeah, that's okay. We're stating a fact that there's an encumbrance there and it could be an issue for the lender, because the lender wants, remember, to convey, for the seller to convey a clear title, right? A fee simple, free of all encumbrances, all liens. So it is not D. So we are not giving our opinion, okay, on the title. It shows it that there's money owed, that there's a lien attached to that title and the warranty deed. And one of the liens, it's typically a loan, a deed of trust. So we're not giving an opinion. We're not making any change. We're just stating a fact. Should they need more assistance, more explanation, they can go to the title company or hire an attorney. All right, number 4. Which of the following is a violation of license laws as they relate to contracts? Okay, violation of license laws like Texas TILA, right? As they relate to contracts. Sorry. So TILA is truth in lending, so not that one, TRELA. So A, using a committee form under certain circumstances. B, entering language onto a contract clause blank that defines what a tenant can or cannot do if the landlord does not make a timely security improvement. Or C, refusing to load language from promulgated contract A into promulgated contract B for the sake of efficiency. Or D, advising a buyer that a contract is legally binding. So which one is a violation of license law? So Texas Real Estate Licensing Act, right? Licensing law. Oh, yeah. Oh. Type your answer in the chatty chat. Take a risk. Type it in. No, that is not a violation of license law D. So that is something that we can inform the buyer. It is a binding contract. A contract is legally binding once it's signed. So violation of license law. So check out number B. Remember, we cannot edit a contract at all or add anything to it or strike anything unless it's a blank that we complete after asking clients our principal questions. So B is the answer. Entering language into a contract clause blank that defines what a tenant can or cannot do if the landlord does not make a timely security improvement. There are Texas landlord and tenant laws. They would have to refer to that. We cannot add anything like that on a lease document or any type of contract. We don't add any language. We add what we're instructed to add into the blanks by the principal. So the answer here is B. So most of you answered C, refusing to load language from promulgated contract A into promulgated contract B for the sake of efficiency. So we will use templates, all right? And we can, so the reason why they're going from contract A to contract B was because the contract A ended up having a counter probably. So now we, create a new contract. And sometimes we just strike out the change that the seller wants, like the price, the days, the closing date, okay, the contribution to buyer closing costs, the home warranty, things in the blanks, and then both buyer and seller can have to initial those. However, sometimes if we want to start out with a freshly clean contract, then we have what? Novation. We have a new contract. So we can merge or populate, okay, from another contract into contract B, and then make the appropriate changes. And then we send it out again for signatures. But we cannot enter languages. Licensees may not define the rights of a principal in a contract, such as what a tenant can do given a landlord defaults. Committee forms may be added with commission permission, advising clients that contracts are legally binding as a required duty, not as an option. So every state has tenant and landlord laws, free online. The agreements, they're already printed contracts that we use. We, again, just fill in the blanks based on the seller and the buyers. All right, number 5. Did y'all understand that? Because the majority of you answered C and D, right? So C and D, advising a buyer contract is legally binding. Yeah, that's a true statement. That's a true fact. Okay. And refusing to load language from promulgated, that's not a violation of law. Okay. We can do that and start a new contract. So we can use what was there from a prior contract, okay, from the same client, because we use templates. However, we don't have to. We can start from scratch. All right, number 5. During the course of a transaction, the licensee must advise clients of various circumstances where legal counsel should be consulted. Okay, in which of the following scenarios should the licensee recommend that the buyer obtain legal counsel? Okay, so during the course of a transaction, so we already have a transaction in escrow, the licensee must advise clients of various circumstances where legal counsel should be consulted to review the title report, or if there's too many exceptions, too many conditions, right? They need advice from a real estate attorney. In which of the following scenarios should the licensee recommend that the buyer obtain legal counsel? A, the licensee is selling her own property and has just hired an attorney to represent her. B, a transaction involving several promulgated contracts. C, a contract for D, transaction involving several non-standard contingencies. Or D, a buyer is about to place an offer on a property where the previous resident had AIDS. So when, so remember, certain things we don't have to disclose. However, when the contract gets difficult and has many challenges, then we can recommend them to an attorney. Oops. Anyone? Come on. So when would you think, use some common sense, okay? Would a sales agent or a broker recommend a buyer or seller to seek legal counsel, a real estate attorney? Anyone? Going once? Going twice? gone. The answer is C. Okay, a contract for deed. So that's a land contract. That is a owner finance, okay, where the deed is not conveyed, involving several non-standard contingencies. So there's several conditions that are not traditional. These types of contracts are more challenging, and most realtors do not have experience with them, especially when starting out. So the answer is C, a contract for deed transaction. That's a land contract. Okay, doesn't mean that it's just for land. That's what it's called. It's an owner selling their property, and they're doing the financing, and they could convey title or not. So when it's contract for deed, the owner keeps the title until the balance is paid, and then they transfer the title, convey the title. Any questions on that? Okay, y'all, we're now going to go into this section. So we're calling it a day. Oh, my gosh. And go and enjoy. Oh, wait a minute. Go and enjoy your evening, take a break, and study more if that's what your goal is. Study in 20-minute sessions, because we remember the beginning and the end of every study. And that's not my recommendation. That is from a book that I read from Jim Quick. Okay, he published a book. He has a YouTube channel, Jim Quick, and I created a video based on 4 pros and cons that he mentioned in one of his videos on how to prepare for studying and things to do, things not to do. All right, so any questions here before we call it a night? And I want to thank you all for being here. You're dedicated. That shows me that you passed this exam. I attended, Zoom calls today, and I did a lot of work for YouTube and my assistant, because I have 2 assistants, right? And I did a DISC assessment quiz or test yesterday that my sponsors put on our Facebook group, the Dream Team. So I noticed that I improved, right? I was such a perfectionist and detail oriented, which I'm still detail oriented. However, I let go of being a perfectionist now that I've been doing a lot of videos, and I handed over, the editing of my videos to others. Before, I thought I had to do it, right? Because I'm a high D, and I was a high D and a high C. So a D is a decisive person, what's another term? A leader, a strong leader, even though I didn't think I was. And then a C is being, in compliance or following rules. And perfectionism, let me see, what did I do with it? Anyway, so should you ever want to find out about your personality trait assessment, doing a DISC, D-I-S-C, you can do a DISC assessment to determine your personality and make improvement. Or if you're working with someone else that you need to learn how to get along with, or how to do business with them, how to negotiate with them. So we have all different personality traits with our clients. So doing the DISC assessment helps knowing ourselves and things that we have to like calm down on. I have to be more patient, more understanding, listen better. I don't take business emotionally, right? I'm very direct and to the point. And I like to educate and teach for those who are interested in learning. So anyway, that's something that I highly recommend. There are free websites. Okay, we got it from EXP in the Success magazine that we own. And it's awesome. I improved from a DC to a DI. DI is, more influential. All right. So any questions? If no questions, hey, if you're watching on YouTube, remember to go and tap that thumbs up, send me some love, send me some support. That these videos, if you can't say anything nice, say it in French, or don't say anything. Don't do a thumbs down, right? Let's keep it positive, because that's what you're going to want to practice when you're out in the real world, and many personalities that we encounter as sellers and buyers, realtors, inspectors, title companies, lenders, all types of individuals. All right. So this is Wild Lillie Handy coming to you from San Antonio with YouTube Agent Prep. So until next time, catch you all later. Bye. If I don't see you on the next one, hey, Happy New Year.